job, every profession, we all sign paperwork. We provide our employer with private information, such as social security numbers and things of that matter. But what action should you take when the private employer releases this type of information? The question is, what exactly are your rights? Our attorney and legal correspondent, David Lesch, now joins us on the show, and he talks about the rights that you have against your employer. Right. And I guess this right to privacy thing is really mushrooming and blooming out.
Well, that's correct. And for the next couple of weeks, we're going to talk a little bit more about your right to privacy as it affects certain areas of the law. But today we're going to focus on your employer, and not just, by the way, not just your private employers, but also the public sector as well. Mm-hmm. I don't know if you remember, a couple of years ago, an employee from the Veterans Administration took home a laptop that had thousands of Social Security numbers of veterans on it, and sure enough, the laptop went missing. It took 3 to 3.5 weeks for the Veterans Administration to speak to all the different agencies that were involved and let the veterans know that their Social Security numbers were lost. Clearly a breach of your right to privacy. What ended up happening was a class action was brought by the veterans, and there were also some individual actions as well, and they sued under the 1974 Right to Privacy Act. It's a federal statute. I'll read some of the language in the statute, which establishes rules of conduct for persons involved in the design, development, operation, or maintenance of any system of records or in maintaining any records. And there has to be rules and procedures that are adopted by the agencies and penalties for noncompliance.
So let me just say that on the basis of the fact that they lost the laptop, they're now susceptible to being sued?
Right. Well, usually the federal government protects a lot of their own agencies from actions against them. But in 1974, there was a statute that was passed that basically said, look, if you're going to collect private information, you're going to have to show that there are protocols in place to make sure that you're protecting this information. And surely an employee who was able to take home a laptop with all this information was not, in compliance with what should have been in effect at the Veterans Administration. And this doesn't just happen at the VA. I mean, this has happened in the private sector as well. It's happened at the YMCA, it's happened at Ernst & Young. Employees take home private information and lose it. Mm-hmm. And then what ends up happening is these Social Security numbers and other things, other areas of your own private information are out there. Mm-hmm. And you never know when somebody is going to get a hold of it and use it and take it and assume your identity. So that's the worst part of it, is you don't even know when this is going to occur, when it's going to negatively affect you. And that's the problem, by the way. Because although you're allowed to bring an action against one of these public agencies for losing your information, and one of the reasons we give you this right under the Privacy Act is that you don't have a choice. Many times you have to give this information to the government, so the government has it on record. So if the government takes your information and loses it, you can bet we're going to allow you to bring an action against them. However, when you go to work for a private company, in many respects, it's your choice to give this information to the company. Mm-hmm. So it's much tougher for you to bring an action against them if the information is lost for a couple of reasons. So there's no statute that you can bring an action under, so you have to bring it under the common law. Well, what does that mean? Well, it's a tort. It's negligence. You have to show more than just economic loss. You have to show that there's something else, some type of psychological harm or some type of physical harm. Well, you can't show physical harm when your private information is lost out there. Mm-hmm. Psychological harm, what are you really going to show? That psychologically you hope that somebody doesn't get your Social Security number and therefore that you can't sleep and you have to see a therapist? It's not very strong.
All right, well, let me turn the page on this. If I fill out an application with my employer, give him my personal information, and my employer decides to share that personal information outside of just the company, problem?
It's very difficult to bring an action against them because there is no statute. And you couldn't bring it under negligence because, again, you have to show more than just an economic loss. You have to show some type of injury. Well, where's your injury? Mm-hmm. And, by the way, how are you harmed? No one's taken your information. No one's used it against you, well, at least not yet. Right? So where's the harm? Remember, when you're suing in negligence, you have to show damages. How are you damaged? No one's taken your identity. No one's assumed, that they're you, and they use your credit cards or anything else based on the information that your employer accidentally let out. So where's the harm? You can't bring an action yet. Do you understand? So it's much tougher. Which leads to, by the way, the private information that is disseminated by your employees, co-employees many times, through, for instance, blogging. Many employees, might give out information about you on a blog. I read a statistic. There are 25,000 to 50,000 new blogs that are started every day, and many employers try and restrict the ability of their employees to blog about the company for several reasons. First of all, for harassment issues. They don't want you harassing other employees because they may be responsible for that, because that's harm. You can show harm, any type of harassment. That's a harm that can be shown. The second reason is, well, what about trade secrets or private things in the company that they don't want employees to share? So they try and limit a private employee's right to blog, and when you start to work for the company, they'll have you sign something. They say no social networking sites having anything to do with our company.
Because a lot of times they block it out.
They block it out.
You don't have the ability to even go on to the Facebook or the Twitter.
I was reading an article in the Times last week. I think it was in the magazine section, about a gentleman who was on Twitter all the time until finally his employer called him in and said, "Hey, you're violating our policy. Either you want your job or not. If you want to keep your job, no more Twitter about what's going on in the company. Do you understand? Shut it down." And he chose to leave the company. But this is the way private employers try and limit damage, so that if you bring an action against them, you can say, "Hey, we had a policy here. We told the employee, and we didn't know he was doing this. So you can't sue us for sexual harassment if he's harassing you on his social networking site." So these are things that private companies try and do, because they know that you do have a right to bring an action against them. It's just not as easy as when you bring an action against the government under the 1974 Federal Privacy Act. So, we as a society try and protect your rights to privacy. The only question is, it's always a balance. It's the balance of an individual's right to maintain their own privacy against the public's right to be able to get certain information. But certainly the public should not have a right to your Social Security numbers or any of your other private information. So here's where the balance really tips in favor of the individual. So it's something that we as a society try and make sure that we protect your rights as an employee, because I'm sure you've had friends or other people who have lost their information, and then the next thing you know, they've been identity theft.
Well, let me ask the question: as an employee, what should you be doing? What are the watchguards?
Well, there's very little you can do once you give your employer your Social Security number for payroll or other things. And what are you going? How are you going? What are you going to do? Walk into the HR department and go through their records and make sure that they're safeguards? You have to ask very nicely, what are the protocols to make sure that my information is safe? Because there's really not much you can do. There really isn't. But with respect to your own information, you have to safeguard it as best as you can, regardless of what your employer is doing. You always have to make sure that you don't give your Social Security number out unless it's it's really necessary. A lot of times during depositions now, when I take testimony from a witness off when it's not in court, but with a court reporter, I used to just ask your Social Security number, and I'd get the Social Security number if I had to do a background check. Now I don't do it. I do it off the record. I'll ask that we go off the record. I'll say to the witness, I'll tell you what, why don't you give me the Social Security number? I'll write it down, okay? And we'll just put the last four numbers on the record to show that you've given me the Social Security number. So this way the court reporter doesn't have it.
Right.
And it's not in a transcript that somebody else can read one day. Do you understand? I'm very aware and cognizant of it. So this is very, very important. So you just have to use your due diligence. Make sure that you protect your private information, and hopefully you won't be a victim of identity theft.
All right. Dio, good stuff.